bringing the appeal for Manchester Ship Canal Company Limited and Vauxhall Motors Limited.
Yes, Ms. Holland.
Good morning, my ladies. Good morning, my lords. I appear with Miss Galina Ward and Mr. Yasser Vanderman on behalf of the appellant Manchester Ship Canal Company Limited, Mr. William Norris QC, Mr. Simon Edwards and Mr. Daniel Stedman Jones appear for the respondent Vauxhall Motors Limited. As you will have seen, this appeal concerns the equitable jurisdiction of relief from forfeiture in relation to licences. And that raises the question of the scope of the jurisdiction in relation to equitable relief from forfeiture. And might I take you at the very outset to what are the agreed list of issues in this case, which is at NS page 56 of the core volume and paragraph 41 of the agreed statement of facts and issues.
Yes, well, you can take it we've read all that, and we've seen the issues that you've agreed, and no doubt we'll deal with them, but they make it all sound quite complicated, whereas actually there's some quite short but very not easy points to be had.
Yes.
So I think...
Quite short, knotty point.
Yeah.
Yes. The reason I was
we thought actually that probably your time estimates may prove to be fairly generous, but so we won't mind if you're able to shorten the argument. But
I heed that.
We'll see how you go.
The reason I was referring to the list of issues at the outset is because technically I may need permission in relation to part of the issues on which I seek to make contentions before you. And that arises from the fact that it's in this court that we seek to advance the contentions that relief from forfeiture in relation to real property is limited to proprietary rights. And that, although we've always taken the approach that a contractual licence in relation to the use of land is not within the scope of the equitable jurisdiction, we've never taken it, the way that the case has developed until now, on the broad scope of the relief. So that's why the list of issues, I've put it to you, necessarily encapsulates a need to look at that broader jurisdiction. But on the footing that it's acceptable for us to proceed on that basis, my contentions will include the issue that relief from forfeiture is limited to proprietary rights in relation to land.
Well, it's an important point. We'd better hear, how would you say? I think Lord Briggs has a confession to make, which is that he's actually written a lecture on this subject.
Well, no, I gave the Denning Society lecture last December, a toned-down version of which is about to appear in the LQR, headed Equity in Business, which was a broad review of Lord Millett's article of about 20 years ago, Equity in the Law of Commerce. About 20% of it is devoted to one of four areas in which I suggested that equity was operating quite properly and in a principled way in relation to commercial transactions. And one of those four was indeed relief from forfeiture. I made it clear that I understood, at least I do in the article, I can't remember whether it was the position in the title of the lecture, this case was pending here, and I deliberately said absolutely nothing about it or the issues in it either way. And I was really moving from Cukurova,
Yes.
In which you'll find me saying that it seems to be generally understood that proprietary or possessory rights are a relevant condition.
Yeah.
I certainly didn't go into any of the issues, and I certainly didn't express a settled view on that point.
Thank you very much.
But I thought you ought to know it's out there. If you want to see what I said, I'm very happy to make it available over the short adjournment in a pre-publication version.
Thank you. That was very kind. Thank you. I was going to set out the respective positions of both parties on each of the list of issues so that we bring some clarity to the boundaries of the arguments, and perhaps I will briefly do that as succinctly as I can. On the first question of whether relief from forfeiture is available in relation to licence to use land and in what circumstances, the appellant says that relief from forfeiture is not available for licences, save in those circumstances where a licence has, for other reasons, attracted the status of an interest in land, whether that may be through proprietary estoppel or constructive trust, or whether it's coupled with a grant. The respondent says relief from forfeiture is available for licensors, and it's not necessary for there to be any proprietary or possessory right, but merely a termination clause intended to secure the performance of the obligations on the part of the licensee. On the second issue of whether it's necessary in order for relief from forfeiture to be available in respect of a licence, that the rights granted are possessory rights over the land itself, it follows from what I've said in relation to the first issue that we say that the rights need to be proprietary, and the respondent says they don't even need to be possessory. On the third issue, what amounts to a sufficient possessory right, we say it's a possessory right which has those added features which make it an interest in land, so a pure possessory right isn't enough. And again, the respondent says you don't need to have a possessory right, simply a termination clause intended to secure performance of obligations. There's then a slightly different issue in relation to 4, which is whether relief from forfeiture is available in relation to a right of discharge of water, which introduces some law on the law of easements. And we say that when that right of discharge gives rise to an interest in land, and is, then it is within the scope of the relief jurisdiction. And again, the respondent's position is you simply see if there's a clause where the termination provision is to secure performance of obligations. And then...
You accept, if it's an easement, you accept that forfeiture is available?
Yes. On the footing that an easement is an interest in land. The fifth issue then turns to the question of the licence in this case as to whether it granted sufficient possessory rights. And we say that even if the test is possessory, then it did not. The respondent's case is, of course, that it did. The sixth issue really wraps up all of the earlier issues insofar as it refers to whether, if relief from forfeiture is applicable to licensors, what principles should be applied in determining whether and when relief from forfeiture is available. And then the final question, putting all those principles together, was relief from forfeiture available in relation to this licence? So,
but I mean, if relief is available, then you're not challenging the exercise of the judge's discretion.
Correct. So perhaps rather unusually, this is a case where I'm going to focus on principle at the outset and turn to the facts at the end. You'll have seen from the submissions that we take the starting point of being the broad proposition that late performance of a contractual obligation will not of itself lead to the intervention of equity. And the most recent statement of the position puts it in very clear and bold terms in a Privy Council decision of Union Eagle and Golden Achievement. And I could just take that up, please, in the Authorities Bundle, Volume 1, at tab 21, 825. I don't need to refer to the facts of this case in any detail. They're very straightforward. It's a situation under a sale contract of real estate, a flat, and the purchaser was just 10 minutes late in tendering the purchase price. It's as simple as that, the proposition which this authority is based upon. And Lord Hoffman said at page 834, halfway down the page, the extract on that page between B and C, the present case seems to their lordships to be one to which the full force of the general rule applies. The fact is that the purchaser was late. Any suggestion that relief can be obtained on the ground that he was only slightly late is bound to lead to arguments over how late is too late, which can be resolved only by litigation. For 5 years, the vendor hasn't known whether he is entitled to resell the flat or not. The specific performance of that contract was refused, notwithstanding that it amounted to a forfeiture of the equitable interest which the contract gave the purchaser in the land. So that's the overriding starting position. Historically, however, for a very, very long time, relief from forfeiture has been a remedy invoked by equity to give relief against termination provisions. And how does that differ? Well, perhaps if I can put it out as a very broad general proposition in the beginning, forfeiture is about taking away something other than simply ending the contract. Something is being forfeited. It is property which is being forfeited, and the usual equitable basis, which is at the root of why the jurisdiction is introduced, is it can lead to a disproportionate deprivation of that property. And it's for that reason that where you've had a termination provision which has ended a contract, but also taken away an interest in property, that equity took the view that forfeiting that property, forfeiting that interest, was unconscionable. And that is why the interest, the property, was restored pursuant to the jurisdiction. And hence that is why the traditional scope of relief from forfeiture has been about leases and mortgages, those types of property interest where there has been, as part of the feature, a regular payment scenario, where breach of that payment obligation can lead to a disproportionate effect of the property interest being taken away, the holder being deprived of that property. And so, in property, we say that that is why relief from forfeiture is linked to whether something is an interest in land. Because in property, when you're talking about ownership, that is what an interest in land is. That is how the system of rules in relation to real estate law, as opposed to personal property law, is premised on the footing that ownership is referable to estates in land and interests in land. So we say that the proper line to be drawn in relation to the availability of relief from forfeiture is already drawn. It's drawn by all those rules which over some centuries now have devised what are interests in land and what are not. That is when you have a property, and that is something where, when it's taken away, there's a forfeiture which then justifies the intervention of equity. Put it another way, the law is already defined in relation to possession what is sufficient for relief from forfeiture to be applied. It's when you have possession, which is exclusive, and for a term certain. In other words, it's a lease. So the question of how, in relation to real property, the type of possession which is sufficient, it's when that type of possession has already been recognised as sufficient in combination with other features to be an interest in land being something that you own, of which you can be deprived, and therefore equity may regard it as appropriate to exercise its discretion and grant relief from forfeiture. So, heeding your words about not making this more complicated than it is, that is at the very root of our case on this appeal.
I mean, well, that's a very simple way of putting it, and it's clear. You're saying that it's grown up for a particular purpose and subject to particular rules, and Lord Hoffman tells us, well, we shouldn't extend it without sort of creating uncertainty and so on.
Yes.
But I mean, this particular case, where it's not at all clear what they thought they were doing in 1962 in granting this licence and asking for a £50 payment and annual, and making but it's certainly as important to the Vauxhall company to be able to continue their use of this discharged water as would be if they had any other sort of interest. I mean, in commercial terms, they were given this over in perpetuity. Why is there a different principle to apply to that?
Well, if I may, I'm going to come to the terms of the licence and what they were actually doing in relation to that in due course. But to answer your specific question, the parties chose a licence. Yeah. And that was the subject of considerable argument in the skeleton argument that we produced for first instance. And the respondents didn't really pursue an argument that it was an easement. Yeah. And the first instance judge, in his judgment, and I can take you to it if you like, it's fairly early on in his judgment, dealt with the arguments which we put in detail as to why it was a licence properly so called, and why the parties had deliberately chosen for it to be a licence.
But that, I mean, is your strongest point. They knew what they were doing. They called it a licence because that's what they wanted to do. And
indeed, the very case of IDC and Clark, which was the authority upon which this point was based and argued at first instance, the very central thrust of that case was that the parties, when they are sophisticated parties, as both the parties in this appeal are, and have the benefit of legal advice, when they choose a licence, one starts off with the presumption that they know what they're doing in describing it as a licence. They had a land transaction elsewhere, they chose not to reserve it as an easement, and all of the features of the licence were very much commensurate with it being a personal contractual right in relation to all of the provisions and it not having the features of an interest in land. And if you'd like me to, when we look at the licence, I can go through those. But for present purposes...
Well, they're going through very carefully by the judge, yes.
But for present purposes, the first instance finding is specifically to the effect that, yes, it was a licence and they chose it to be such. The part of the judgment, perhaps I will just take it to you if I may, it's at, yes, at paragraph 86 is the conclusion on the point, but if one goes to MS page 168, and to paragraph 83 on that page, you'll see the reference to the authority I mentioned a moment ago, where Lord Justice Norse had stated the proposition from the second sentence of the quotation: in deciding what this professional draftsman intended in 1969 by the use of the expression grant licence, we must start from the proposition that for over 300 years it had been well known to lawyers in general and to conveyancers in particular that a licence properly so called is a permission to do something on or over land which creates no interest in it. Thus in Thomas and Sorrell, Chief Justice Vaughan said, a dispensation or licence properly passeth no interest, nor alters or transfers property in anything, but it only makes action lawful, which without it had been unlawful. Miss Holland-QC accordingly submitted that I must approach the construction of the 1962 deed in the expectation that when the draftsman used the expression grant licence, they intended to grant a licence properly so called, and no more. There's then a paragraph about some of the detailed submissions, and then at paragraph 86, His Honour Judge Barron says, I agree with Ms Holland-QC that the 1962 licence created a licence. Whilst I do not agree with her analysis in its entirety, I do agree with most of it. I accept in the light of Clark that the use of the word licence is of considerable importance and that it is for General Motors, which was at that stage used as the name for the respondent, to establish that some other interest was intended. I also accept the other terms of the licence are consistent with a licence, though some of them are also consistent with the grant of other interests.
Yes, well, we've read that. Thank you.
Now, included within our submissions in developing the point that relief from forfeiture is about taking away something which is an interest in land, we've also included the law from Street and Mountford and Ashburn and Anstalt, where the courts have decided that a contractual licence is not an interest in land. So that decision has been made as a matter of policy, very clear law in Street and Mountford and Ashburn and Anstalt, to the effect that a licence is a licence and a lease is an interest in land. I wasn't proposing to take you to that.
I don't think there's any dispute about that, is there?
No. My point for present purposes is that the exercise has already been gone through for a very long time of drawing the correct boundaries.
But not for the purpose of deciding whether or not relief from forfeiture is available.
No.
I entirely accept, I
Absolutely.
think, virtually all you say about there being a long-established distinction for interest in land purposes
Yes.
between leases and licences, and indeed between easements and licences.
Yes.
But I think we are now having to grapple, aren't we, within the land context, as you say in your case, with whether that is the appropriate boundary, if you
Yes.
like, for the proper intervention of equity.
Absolutely, which is why I've linked it in, and we put it the way in our submissions, that because the law has decided what owning something is in real property purposes, and because relief from forfeiture is about taking away something and doing more than ending a contract, that boundary line should be exactly at the boundary line of interest in land.
It's not a boundary upon what you would call the wrong side of which it's impossible to say as a matter of substance that what is being taken away is in some sense property, or some sense more than just the contract. Is it? Or do you say that it is?
Forgive me if I'm not...
Because I think you're focusing your point on possessory. Or proprietary.
We are focusing our objections to the way that the Court of Appeal have dealt with it,
Yes.
and the respondent submissions in this court, that possessory alone is wrong. However, our first position is that it's interest in land, and it's possessory when it's an interest in land, which is sufficient. Does that answer your question?
No, my question really was this. Is it your submission that this, I think you said earlier that forfeiture is about something other than just ending a contract.
Yes.
Some interest in property is being taken away in an unconscionable manner. And I was simply asking you whether it's right to say that the well-established boundary between interest in land, lease or easement, and a licence creating no interest in land necessarily defines for all purposes, and in the sufficiently broad sense, all kinds of something more than just contract, which is being taken away in a forfeiture situation.
I do say, in relation to real property, that it is that boundary line.
Yes.
I do say it's that interest in land, yes. And of course, interest in land has already a great deal of flexibility built into it because of the law of proprietary estoppel, because of the law of constructive trusts, because of the law of licenses coupled with a grant, for example. Unconscionability comes into a degree in relation to the deprivation of something you own, but after that, unconscionability is within the scope of the exercise of the discretion as opposed to the jurisdiction. There's a quotation from Snell's Equity, which has appeared on various occasions in this case and indeed is relied upon by my learned friends, I think, today. And I wonder if it might be a convenient moment just to look at that in relation to the question that's been raised. It's in the Bundle of Authorities, Volume 3. At tab 52, page 1428.
1428.
Yes. And at page 1430, the start of the paragraph which is being referred to is the final paragraph on that page. It is nonetheless submitted that the conventional formulation that relief against forfeiture is available only in respect of a proprietary or possessory right must be treated with some caution. Just pausing there, obviously we're in Snell's equity, and in this chapter doesn't make any reference to distinctions between real property law and personal property law. But it goes on to say, if, for example, B has a purely contractual right against X and then mortgages that right to A as security for a loan, it is submitted that in line with the approach taken by the Privy Council in Cukurova, Finance International, Alpha Telecom Turkey Limited, there is no reason in principle why B could not seek relief from forfeiture if A attempted to retain that contractual right. The point is that B initially held the right independently of the contract with A, and prior to that contract, A had no claim in the right. In a case such as the scap trade, the supposed forfeiture, in contrast, consisted of no more than A simply seeking to bring to an end A's contractual obligation to B, and it is very difficult to justify a jurisdiction that would prevent A from stipulating in any contract with B the conditions on which A is entitled to cease to provide the contractual service to B. The case of a lease of land is treated differently, and this has sometimes been linked to the potential availability of specific performance to be the lessee in that context. The more pertinent point, and I think this is the relevant sentence, it is submitted, is that as the granting of a lease gives B not only a contractual right, but also an immediate property right in land, the termination of A and B's contract in that case does more than simply end the parties' contractual relations. So that's where it's starting to allude to what is at the source of relief from forfeiture, we say, in relation to real property. Now, unless I can deal with that aspect of matters in more detail to assist, I was proposing to move to what is a very central theme of our submissions in the way that the law of forfeiture has developed. In developing the point which is set out in our appellant's case, that the test in relation to relief from forfeiture being pronounced as proprietary or possessory has effectively evolved almost by accident through the back door. And this arises from the fact that all of the legislation in relation to relief from forfeiture is based on leases. Licenses aren't mentioned in the legislation. The leading educational textbooks that students learn from at the moment says in very clear terms, only a tenant, not a licensee, may ask for relief from forfeiture. So how have we got to this stage where we're now questioning this and looking at it from possessory? And we say that that's only because of the way that the cases are perhaps unusually evolved here.
But yes, I mean, you've followed, it's been very, very interesting to see how it sort of starts off with Lord Diplock and a piece about charter parties and
Yes.
so on. I mean, what's more interesting, I suppose, is the fact that although it started in that slightly haphazard way, you might say, nonetheless it's been adopted as a test by judges of great authority and has acquired one might say, a sort of validity of its own, which is then, which we would be upsetting. So I don't think we need to go back into all the cases.
I'm most grateful for that, and the fact that, as you obviously appreciated, it did have that very unusual beginning, and I won't go through all of that, but it is very significant in relation to how we are here on this issue, because, as you can see, the scap trade, which was in 1983 from recollection, we've had various cases, but only now is really that evolutionary accident, as I do so describe it, coming to the fore. And I'll take you then, if I may, I won't go through the fact that how Lord Diplock obviously was using the language purely to distinguish between time charter parties and charter parties by demise. And it's clear from his other case on charter parties by demise and time charter parties, that is exactly the language he was using for that purpose. But the essence of his decision was saying an awful lot more about the restricted scope for relief from forfeiture. And perhaps I could take the scap trade up, if I may. It's at divider 14 in volume 1 of the Bundle of Authorities.
Electronic number, please.
And it's at 717.
Thank you.
And I'm going to go through what I would suggest to you are the principal authorities. Scandinavian Trading, then the Sport International case, Bundy and BCCI, and Kukurova, to show this process. And I'm going to do it from a dual purpose perspective. The first being how the test has accidentally evolved, but secondly, to also look at how these authorities very clearly reject what is the respondent's case in this matter, that relief from forfeiture does not depend solely on whether there is a termination clause which has as its object the performance of obligations. So the reasoning in these cases is very much linked to both. So I'll deal with their case at the same time as setting out our case in relation to these.
Are you going to say anything about Shiloh, Spinners and Harding, or
I'm
do
going
that
to,
your reply?
I thought you might say that, because I deliberately decided to start with the scap trade, and we'll go back briefly to
Perfectly
Shiloh,
happy with
Spinners.
that.
Is that all right?
Yes.
Right, so where are we looking in scap trade?
So if I could ask you to go to page 723, please. 723, letters G to H.
Yes.
And this starts to set the scene in relation to the matter. A time charter, unless it is a charter by demise, with which your lordships are not here concerned, transfers to the charter no interest in or right to possession of the vessel. And really the relevant part of this decision, if we then go over the page to page 724, and it's not the clearest of starts here, but this is where Lord Diplock starts to deal with the essential proposition that is put forward by my learned friends on this appeal, that if you have as the object of a termination clause performance of obligations, and he deals with it by reference to the argument having been put forward in the Laconia, and I don't know whether you're happy for me to read out. I'm proposing to look at the paragraphs from 724E down to 725E, or whether you'd prefer to read those.
Shall we
to
read
yourselves.
that for ourselves?
I'm most grateful.
Right. Okay.
Thank you. And then could I ask you to look very briefly at page 727 at letter G.
What, that it's directed to
Restricted.
time charters? Yes.
Yes.
I mean, the previous passage presumably wanted us to see what he says about Shiloh spinners and the limitations of that.
Yes, there are two central points really that I invite you to focus on from this case, and that is the paragraph from G to H, where there is a very clear rejection of the argument that relief from forfeiture simply depends upon whether there is an object of the termination clause being performance of an obligation.
Yes.
Very, very clear rejection. And then the paragraph, which is at 725C, which was an equally clear statement that there is an additional matter, and that the statement in Shiloh, Spinners and Harding wasn't freestanding in that his words were, contracts not involving any transfer of proprietary or possessory rights. And I say those two paragraphs can't be clearer in both, firstly, rejecting the argument which the respondent takes in this case, and secondly, that when he made the comment about it being contracts not involving any transfer of proprietary or possessory, that was linked to charter parties that were time charter parties, not charter parties by demise.
Yeah.
And just standing back for a moment, therefore, it's somewhat ironic that in the scat trade, when the purpose of Lord Diplock's observation was to distinguish time charter parties from charters by demise by saying that charter party by demise is something else, it's transferring something else, it's analogous to a lease for which relief from forfeiture applies, that we're now in the situation that that authority is being relied upon to achieve the opposite result here.
But as I said, it's not just that authority.
Absolutely.
The way it's been developed in later cases.
Absolutely.
So,
Now, before I go forward to those authorities, just to deal with Lord Briggs's point about Shiloh, Spinners and Harding, that's at the next divider in the bundle of authorities, volume 1.
yes.
And the facts of this case, very briefly, concerned assignment of a lease.
We have an electronic page number.
Oh, I do apologise, 729.
Thank you.
A decision in 1972 of the House of Lords concerning an assignment of a lease. And there was a covenant in the assignment in relation to the performance of obligations regarding fencing and support. And in order to ensure the enforceability of those covenants, a right of re-entry was inserted in the assignment. To support that, the assignee assigned onwards to the plaintiff, and the right of re-entry hadn't been registered as a land charge. When the assignee tenant sought to enforce the right of re-entry, there was a good deal of dispute about the extent to which the right of re-entry was protected in relation to the registration situation. However, the House of Lords also had to consider the question that if the right of re-entry was enforceable, whether relief from forfeiture could be granted in respect of that right. The trial judge found that it was enforceable, but held that there was no jurisdiction to grant relief. That was reversed in the Court of Appeal. In the House of Lords, the decision was that the right of entry was enforceable because it didn't need to be registered. There was jurisdiction, but on the facts, it wasn't right for the discretion to be exercised in favour of the applicant. And in the opinions, if one goes, please, to page 759H, and if I might take the matter up exactly at line G, where after the reference to Barrow and Isaacs, the sentence begins, I would fully endorse this.
I think I've misheard your page number.
761.
Thank you very much. Yeah.
It remains true today that equity expects men to carry out their bargains and will not let them buy their way out by uncovenanted payment. But it is consistent with these principles that we should reaffirm the right of courts of equity in appropriate and limited cases to relieve against forfeiture for breach of covenant or condition, where the primary object of the bargain is to secure a stated result which can effectively be attained when the matter comes before the court, and where the forfeiture provision is added by way of security for the production of that result. The word appropriate involves consideration of the conduct of the applicant for relief, in particular whether his default was willful, of the gravity of the breaches, and of the disparity between the value of the property of which forfeiture is claimed as compared with the damage caused by the breach. And that is the paragraph that's been cited subsequently, we've already looked at in the scap trade. So that case was 1972, the scap trade was 1983, and 1984, the Sport International and Bussum decision adds further light on the situation. And if one turns to, it's page
Sorry,
7.
we looked at Shiloh Spinner's why. I mean, that particular sentence would be against you. He's saying we should have a right to use forfeiture where the object of the exercise is to ensure payment. And that's what we have here.
Well, why I say that that isn't against me at all is that what is clear from that paragraph is that Lord Wilberforce was saying it's in appropriate and limited cases.
Well, that's, I mean, appropriate. He's dealing with the question of discretion, isn't he?
He is. And we'll see when we look at the later cases that there's some discussion about the word limited.
But your real point, surely, is that this was, on any view, plainly a proprietary interest in land.
Absolutely.
That was the subject. Although the right of re-entry was reserved in an assignment and not connected to a reversion, the subject matter of the forfeiture was an interest in land.
Exactly. And in each of these cases, and this is the point I was going to come to, in each of these cases, either you've got a very clear proprietary right, which there's no occasion to venture any comments, or we're very clearly in the situation of personal property, where again there is absolutely no occasion to be making any statements from which conclusions or inferences can be drawn in relation to real property.
Right, so we've got Shiloh Spinners, which is proprietary. We've got the scap trade, which wasn't. Where do we go from there?
We go next to Sport International and Bussum, which is at page 777 and divider 17 on the paper copies. And this one concerned a breach of an agreement in the beginning where the defendant had been granted an exclusive right to purchase sports shoes from the plaintiff and to resell them. That led to proceedings, and the proceedings were compromised by way of a Tomlin order, under which there were to be payments of $105,000 in 3 instalments and an obligation to provide a guarantee. So that was the backdrop, purely contractual. When the payments were late and the licence was determined under the contractual provisions in the Tomlin order, relief from forfeiture was sought. So that is how the facts raise the question of relief from forfeiture. And in relation to this case, I was proposing to take you to the Court of Appeal and the House of Lords, the Court of Appeal judgments being more extensive. Mr. Justice Staunton, at first instance, found that there was no jurisdiction. And if we go to the Court of Appeal and Lord Justice Oliver, and it's at page 785, and this is, I think, perhaps the most extensive citation that I was going to ask you to look at, from page 785D, through to 787F in the beginning.
785D.
To
to
787F in the
Yes.
beginning, yes.
And what are we going to get from all that?
What you're going to get from that is the discussion of the passage from Shiloh
Yes.
that we looked at a few moments ago, its treatment in Scandinavian trading, and some discussion of the argument which is put forward by the respondents that you only do
And
need
you're going to want us to adopt this, are we?
No, I think it's just an important part of
Well, I mean, I want to know whether you're saying this is right or whether you're saying it's wrong.
I'm saying it's right.
Okay.
But there is a House of Lords...
It's useful to know beforehand
Yes.
whether we
Yes.
want us to read it with a favourable mind. All right, well, we'll look at 785D. Thank you.
One always reads everything Lord Justice Oliver says with a favourable
Well,
mind.
up to a point.
787DF,
Absolutely.
before the quote.
Before the quote, I was wanted to pause there because that's a good moment to pause on this particular judgment, just to reflect on what has been said so far, and it's particularly the paragraph at 786E to G, where there is a very clear rejection, again, of the respondent's case.
Even when advanced by someone very persuasive in the form of
Indeed
Mr.
so.
Hoffman QC.
Absolutely. It couldn't be clearer than that paragraph beginning. Now, certainly in the passages quoted, Lord Wilberforce was complaining the jurisdiction in some cases where the primary objective forfeiture is secured, but he cannot, we think, have had it in mind that the jurisdiction was expel wherever the stated condition existed.
I'm not sure that the respondents go quite that far, do they, Ms. Holland? I mean, they say there has to be some sort of property, but it doesn't have to be possessory.
Forgive me, could I just ask you to repeat that?
Yes, I'm not sure my reading of the respondent's case goes quite as far as you suggest.
Well,
Nearly, but I wonder if it goes quite as far.
well, in fact, I'm perhaps jumping ahead in relation to what I was going to say on this, but we too are very unclear as to whether the respondent's case is that you have relief from forfeiture where the termination clause has as its only object the performance of obligations, or whether it is the case that they are saying it's where it is a purpose. If one goes, for example, to the core volume at page 115, you'll
Yes,
see that
paragraph
their
99.
conclusion is
So which page are we on now?
we're at 115 in core volume 1.
A right to use property.
And what their conclusion is that the court only has to ask 2 questions in relation to relief and forfeiture regarding the jurisdiction before you move on to discretion. Does the clause in question terminate the right to use property, corporeal or incorporeal? Is that right of termination intended to secure the payment of money? But in fact, if one looks elsewhere in the respondent's case, there is a good deal of ambiguity. If one looks, for example, that paragraph 98, there is reference to an article, and we'll see what the respondent says about this article, but it's absolutely clear that the proposition advanced in that article is that the object of the clause, if the only object of the clause is to secure performance of obligations, that's all you need for relief from forfeiture. So if they're adopting that, that is their proposition, my lord. Now, I could go through other parts of the respondent's case. So if you look at paragraph 79...
Well, let's not do it. We'll get it from you in due course. I think it's more helpful. We were on looking at the authority, and we were looking at the Court of Appeal for Justice Oliver, who obviously carries considerable weight. But we also, broadly, this case supports your position that the right to forfeit is confined historically to very specific areas and shouldn't be extended just because of certain analogies. I mean, we get that from Lord Justice Oliver, we get that from Lord Justice Robert Gough, who's quoted. Where do we go from there?
So where we go from there is, I said we were just taking a pause in Lord Justice Oliver's decision, and we left off at letter F on 787 before the quote.
Yes.
And just to finish off what he says, if I could just ask you to read from D to F on page 788.
Yes.
And that's where he says it's got to be proprietary.
Yeah.
And he doesn't appear to include possessory.
Correct. And then if I could also ask you...
I mean, it's quite a helpful passage of Lord Justice Robert Gough, from your point of view, at the bottom of page 788 and top of 789, which is to similar effect.
Yes, this is one of those unusual situations where the internal page referencing is almost identical to the MS page referencing, which is apt to cause a little bit of confusion.
I see, that's confusing.
I'm
using
you're
MS
absolutely right, my lord, that we're looking on that page. And if I could ask you to look at C to E on page 789.
Yes. C to E.
Yes.
Yeah.
So that we're moving a pace in relation to this, I'll now move on to the House of Lords, where it's Lord Templeman's who opines on this matter. And it's fairly brief. If one goes to page 794, at the bottom of the page, the 2 lines on the bottom of page 794 to 795E, that is what Lord Templeman says on the topic.
Where at the bottom, 794?
794, the last 2 lines on the page, and then 795E.
Yes. So that doesn't help either of you very much.
Well, what I
Well,
took-
he says that on the facts of the case, there's no case for extending the well-recognised boundaries. They were parties locked in difficult litigation, wholly at arm's length.
yes, insofar as he says anything general, he's saying it doesn't apply to contractual licences. Yes,
So you rely principally on what the Court of Appeal says. Though.
Mere contractual licences.
mere contractual licence. You're quite right. I stand corrected.
Right, well, we got that.
Now, there's a variety of other cases which deal with the test in relation to personal property, but I think the one that is of significance, of the final one that I'm going to take you to on the principal points, is the Kukarova decision, which is at tab 5 of bundle 1, and it's page 463.
Yes.
Now, there was a rather complex factual background to this, but the essence of the matter was that the situation was that there was an equitable right to redeem secured property, which had been secured for a loan. That's all I think one needs to know for the purposes of the relief from forfeiture argument. And so there's no question here, again, of there being any factual context which brings to the fore the question of the boundary lines for relief from forfeiture in relation to property. It was an established form of relief from forfeiture and mortgage situation.
But we'll save that it wasn't an interest in land. It was a mortgage of shares.
It was a proprietary right for mortgage of shares, yes. Established scenario.
So
for
it's
relief.
a long judgment. Where do we go?
Could I ask you to go, please, to page 495? And so paragraph 86 sets out that factual context. Then there is reference to Lord Wilberforce in Shiloh at paragraphs 87 and 88. At paragraph 89, there's the discussion of the scap trade. In paragraph 90, there's reference to the point that I just made. The commonest cases in which equity has power to intervene were identified by Lord Wilberforce as mortgages.
This is the judgment of the board.
It is, yes.
Unanimous.
Yes.
Yes.
And paragraph 91 makes the point that it's precisely the position here where it's a case of a mortgage. And I do apologise because I flicked over a page too quickly because I meant to take you to BCCI and Burnley first of all. I'm so sorry, but perhaps I'll carry on with this authority anyway and come back to BICC.
We've got the quotation here, haven't we?
Indeed, and that's what made me realise what I'd done. So there's the relevant part of BICC and Burnley is in paragraph 93, which is quoted here. And so could I ask you, please, just to look at from paragraphs 93 through to 96.
But I mean, this is Lord Justice Dillon taking a completely different line to Lord Justice Oliver. Lord Justice Oliver
correct.
saying we should stick with the lines we know and not extend them. Lord Justice Dillon saying, well, why not?
Well, there is two very different points here, which I think are apt for confusion, because there is no doubt about it that the case law on the Burnley decision and in Kukarova says that there is no reason to restrict the subject matter in which the rights for which relief from forfeiture might be exercised. There is no reason to restrict that to real property. The subject matter. But that is not to be confused in my submission with these cases saying anything further about extending the rights which have to exist in that subject matter for relief from forfeiture jurisdiction to be applicable. And what the respondents in this case seek to do is very much confuse those two. Confuse the subject matter, which, yes, there has been a good deal of a sea change on the case law regarding that. But what there hasn't been, in my submission, is any reasoned change in what the rights have to be.
Yes, I see.
Well,
So,
subject to this, that Lord Justice Oliver in Sport International was really plumping for proprietary rather than possessory, whereas what is specifically approved is a proprietary or possessory class enunciated by Lord Justice Dillon in the Burndy case, with which the board, in terms, agrees at the beginning of paragraph 94.
Yes, you're quite right, which is I think why a few moments ago I just qualified it with the insertion of a word. But what that goes to, my lord, and I don't really resolve from anything I just said, because what it goes to is our point that we've developed in some length in our appellant's case, that what is a possessory right in relation to that extended subject matter equates to ownership in personal property law. And so when there's language which I totally accept has been an acceptance of those words from Lord Diplock in the Scattrade, in those later authorities, it's made great logical sense, my lord. And I haven't read your article, but in relation to personal property law or the extension, there's absolutely no reason to disagree with the test of proprietary or possessory.
Don't worry, my article's flying at a level of generality somewhere in the ceiling, so far as this point is concerned.
So I make absolutely no issues with any of these authorities whatsoever. There is no sentence in any of these authorities that I take issue with in putting forward the appellant's case.
so this line of reasoning here, the adoption of Lord Justice Dillon, you say, is fine as far as goes for personal property, but doesn't help one at all in relation to land.
To be clear, what I say is all of these paragraphs in these cases where the focus has all been upon extending the subject matter for relief from forfeiture and there being no good policy reason for not extending it, all of their focus has been on subject matter. And what isn't appropriate is for that language to be then interpreted as applicable to statements about real property law, which they were not concerned with.
Yes.
But that requires you, doesn't it, to extract from the Scattrade line of cases your submission that possessory in the personal property cases with which those decisions are concerned means something like ownership.
Yes, and that's what we
And I
do
wonder if
say.
that distinction really emerges, for example, by comparing a time charter with a charter by demise or a bareboat charter.
Well, in relation to that...
Does a demise charter give you any kind of ownership of the ship?
Yes, there are some references. So in relation to the two questions that you've just put to me, what we say is that so far as the extension of subject matter beyond real property, possessory is an appropriate word which does reflect ownership and works well. In relation to the second part of your question, it's a really good example of the situation of the time charter party and the charter party by demise, because that is exactly what Lord Diplock was seeking to do, and I can find the references, if you'd like me to do so, where, and I think the very first quotation I took you to from the Scattrade of Lord Diplock was where he made that clear distinction about a charter party by demise does pass the interest. And that was why I referred to it. Just to remind you, it's at page 723 of the first bundle of authorities. It was that sentence that I read out, a time charter, unless it is a charter by demise.
By which page?
723.
723.
Authorities Bundle 1.
Well, there may again be an undistributed middle, because he says interest in or right to possession of,
Yes.
and he
That's
says it's just a contract for services to be rendered to the charterer by the shipowner through the use of the vessel by the shipowner's own servants. So it doesn't even give the charterer the use of the vessel.
That's a time charter. But the point that I'm seeking to make, my lord, is the distinction in the first sentence. It's the first sentence which I'm focusing on here, where he's actually doing the very distinction which we say applies here, where he's saying a charter by demise. He contrasts it with a charter party by demise. A time charter transfers no interest or right to possession.
Or, yes, interest in or right to possession.
Yes. So he's contrasting that. It's a contrast with the charter by demise, where it does do that.
But you were saying that possession in the personal property case is equivalent to ownership. But his concept of possession here is surely much wider than that, isn't it? Because the interest in would be something like ownership, whereas the mere right to possession of the vessel for the duration of the charter might fall well short of anything that could be described as ownership, but is nonetheless something sufficient to attract the doctrine.
But that's because it's by demise. That's the possession. So the demise isn't in the same way that real property law, a lease, doesn't transfer. There isn't one form of ownership. Possession by demise, that's what you're doing.
Why didn't he just stop with interest in?
Sorry?
Why didn't he just stop at interest in the vessel?
Because there's a danger here, if I might suggest it, of confusing the word interest in real property law with chattel here.
Yeah.
With chattel. Because interest in real property law, interest in land, has a specific meaning equivalent to a form of owning something. Interest here is meant by reference to a proprietary interest. Or right to possession can be equally applied to having a demise and having possession for a long period of time, for example, which gives you a form of ownership in the same way that that form of ownership, a lease, gives you a right to relief in relation to real property. And I think, but I can't remember exactly where they are, there are some other examples of a charter party by demise being so described and that distinction. So insofar as one can draw any analogies between chattels and property, that sentence is as good an example as one can find in my submission.
Why isn't it enough that it's simply protected because you have a contractual right to use it to the exclusion of the person who's trying to interfere?
The answer to that, Lady Auden, we say, is because a contractual right, as the authorities still accept, isn't something in the form of property for which relief from forfeiture takes the view that you are being deprived of. It's purely a contractual right.
But that's a conclusion. It's not a reason.
I think it goes back to the fact that when, for example, there's a transfer of land, if I was the transferee under a transfer of land, I have the benefit of a contract, but I have something else as well, because I now own a property. And that is what is very fundamental to our case, that it is not simply a right of contract. I also have something.
I know that is your case, but I was just really trying to winnow out why you have to have that form of possessory right, why it's not enough that you simply don't have the right to use it and to stop anybody else interfering with your use.
I think there are two answers to that question, really. One is an overall answer, which is that there is sanctity and freedom of contract as the general theme, is that the bargains of men are to be respected and are to be complied with. And there is that fundamental proposition that when we agree terms of a contract, they are what are to be applied. Insofar as equity ever seeks to step in to undermine that philosophy, it does so in certain circumstances only, and those circumstances are divided into two. One is to decide where the jurisdiction is applicable, and the other is to decide when, on the facts, it is appropriate. In relation to the first of those, it has decided, in the way that I referred to earlier, that it will step in when you own something and you are being deprived of something, my central point. And that is why it is fair and right to only override freedom of contract in those circumstances. Anything beyond that would be too much of an intrusion and a trespass upon that general principle about contract. I hope that answers.
Well, yes, I was just thinking possibly the parliamentary intervention, which has been partial. For instance, under Section 146, to protect forfeiture in the event of a lease, means that equity would be reluctant to go into analogous property rights because it would be perhaps seen to be interfering with Parliament. But we're not in that field. In fact, Parliament has extended Section 146 to apply, I think, to tenancies.
There's a very complex background to the introduction of legislation in the field of landlord and tenant relief from forfeiture. On parts of what you've just said, dealing with them in turn, Parliament didn't introduce relief from forfeiture for leases. It was already there, pursuant to the inherent jurisdiction. What Parliament did, through various provisions, it introduced new restrictions, it did various deeming things, but it didn't destroy the inherent jurisdiction which already existed. So the point we take from the legislative background is that legislation has accepted that in the real property world, the very fact that that legislation only applies to leases is, of course, very much a recognition that it is only leases to which relief from forfeiture applies. So it didn't change the scope of the jurisdiction at all, because relief from forfeiture already applied to leases.
I may be wrong, but I thought the Parliament had left out tenancies, residential tenancies.
No, I don't think that's...
For which a right of re-entry remained. Anyway, it doesn't matter. But my general point was, once you get statutory intervention, different problems arise for equity.
Well, I think to assist in relation to this, the inherent jurisdiction of relief from forfeiture does still have some application in certain circumstances where the legislation doesn't apply in relation to leases or mortgages, if that assists. But it hasn't been the case that there's been, as far as I'm aware, there's been any legislative occasion on which Parliament has decided to increase the scope of application of relief from forfeiture. In relation to I'm trying to think, on the residential side, forfeiture applies, and I think it may be, my lady, that what you might be referring to, if I might respectfully suggest, is the restrictions that Parliament has put upon forfeiture in the residential context by the housing legislation, so that people can't just have their residential homes taken away pursuant to forfeiture. There are additional statutory restrictions.
But Parliament had to do that. I mean, including right of re-entry within forfeiture.
Parliament did that, correct, yes.
But I mean, I think your point is that those legislative provisions are all based on the assumption that forfeiture is available and relief from forfeiture is available in respect of leases.
But not
But they don't really deal with anything licenses. I mean, the assumption has been that licenses are free from those sort of, that sort of baggage.
That is indeed our proposition,
And that
yes.
seems to be Lord Justice Oliver's approach. But we're now faced with the Privy Council adopting the approach of Lord Justice Dillon, which seems to be rather more flexible. But you say only in the context of...
Subject matter. Wasn't saying anything about rights.
Yeah. Well, that's where we stand.
Yes.
Are we going to get any more help from anyone?
Before you go on, can I just ask you to reduce this to really basic propositions? as I've understood it, if we're talking about non-real property, we're talking about chattels, shows in action, that anything which isn't real property, you say only ownership will give you a right to ask for relief from forfeiture. Can I give you the second half of it?
Yes.
And in real property terms, you have to translate that, and then you need a proprietary interest. Possessory won't do. Is that boiled down?
Could I just add a bit more of a gloss to that, if I may? We start off with real property being the subject of relief and forfeiture, where ownership is in relation to estates in land and interests in land. So that's what we mean by ownership in the real property context. When we come to personal property law, which you know from our submissions has developed a totally different set of rules about ownership, in that context, you have ownership, which is, whereas you have it by reference to estates and interests in real property law, you might have it by reference to bailment and possessory rights in that context. It's a different language which is being used.
And you could have relief from forfeiture in a bailment situation?
You can have relief from forfeiture in a bailment situation.
But not in an equivalent possessory situation in real property?
Because you don't even get to bailment in real property. You have, there's no lesser, it's no lesser type of right, bailment, than what you might get in the real property context with a lease. It's the danger of trying to compare two totally different things, and the rules about what are possessory rights in relation to both, where I say in personal property law they've been working out where you've got a sufficient ownership right, whether it be by possession in the personal property context, whereas in real property law it's very well established by reference to interest in land and estates in land. So,
are you going to explain to us at some point how far possessory rights in the context of personal property extends?
Yes, now we did think about this in relation to the appellant's case and decided that a thesis on personal property possession probably wasn't the right course. But what we've done, therefore, is to give you some examples, and perhaps if I could take you to two cases which do give you that example. And the two cases are Celestial Aviation as an example where relief from forfeiture wasn't granted. And the other case I'll take you to is the On-Demand and Michael Gerson case, where relief was granted. And I think that may give you a sort of answer. On the Celestial Aviation case, it's at page 435 of the first bundle of authorities. So just to be clear, this therefore is an example of a case where relief was granted in respect of a mere possessory right in personal property. And the facts were that the claimant in that case owned 3 aircraft, and they were leased under 3 agreements for 8 years. The rent was payable monthly in advance, and then there was a supplemental rent, which was to build up a fund for maintenance purposes. Time was of the essence, and on default, there was a termination right. And if I could ask you to read the head notes at the bottom of page 435.
What, the holding?
Yes, please.
Yes.
So that's a sort of situation in which relief is refused and there is no jurisdiction. And if we then go to page 638, actually,
So the principle that you would seek to draw from celestial aviation is that the possession must be more than an economic interest. It must be possession with a view to, or which may lead to ownership.
one goes to page 450.
Yeah.
Take you to page 445 at letter H.
Right, who is this? Oh, Mr. Justice Hamblin.
Yes.
Yeah.
445 at letter H.
Paragraph 50.
Yes, in fact, if you look at 48 and 49, it deals also with the Charter Party point that we touched on earlier, I think.
Sorry, what would you like us
So
to read?
445,
Yes.
if one looks at where it's introduced at 48 and 49, but then particularly at the second sentence in paragraph 50.
Yeah, some sort of expectant property right. Is that the key word?
Well, there's then a further discussion.
What do you seek to draw from paragraphs 49 and 50?
The stressing in paragraph 50, or just bear with me while I go back to it. The movable property cases in which jurisdiction has been held to exist involve not merely a possessory right, but also a proprietary or expectant proprietary right.
It's the expectant proprietary right in the sense that you're not going to have to give it back.
Yeah.
And either it'll revert to you lock, stock and barrel at the end of the limited period. But well, no doubt you'll come to the problem with this case where it's a perpetual licence. So it never goes back. It might be said that the ship canal's interest is therefore purely economic. On the other hand, it doesn't mature into ownership either.
Correct. I've got a lot more to say on that topic.
Yes, I'm sure.
But for the purposes
Can we
of your,
just deal with
premise of
this
your
case?
question.
We've looked at paragraphs 48
Yes.
to 50, and we see the distinction that Mr. Justice Hamlin's taken, and one sees how it fits on the facts of that case. Where do we go from there?
So I was going to take you to the example.
There's a very useful passage from Lord Justice Robert Walker in the on-demand case, which he sets out.
Which is what I'm going to take you to next
We
at
got
638.
Do we get anything else from Celestial Aviation?
No, I want you to take you to the on-demand case, if I may, at 638.
Yes. Where's that?
638.
I thought you were going to take us to 450.
Yeah.
At 450, my lords, ladies, that's where there is the discussion of the legal policy reason, and it goes through the various cases. And at the bottom of page 451, having gone through those cases, there is reference to what we started off with, which was Lord Hoffman's statement in Union Eagle.
Well, he's there setting out the authorities which he's seen, which talk about the strong policy reasons for not extending.
Yes, but the reason for my perhaps hesitating is that I don't really think that in those following paragraphs there's any purported statement of general principle which would answer Lord Kitchen's question, which is it just goes through the authorities.
No,
and
I mean,
it
we're
decides.
dealing with a case which you say illustrates a situation
Correct.
where the judge, for good reasons, thought it wasn't appropriate to extend the jurisdiction.
Correct. Yes.
Even though arguably there's an element of possession.
Yes.
Right, so there we go.
At 638.
Sorry,
Which
paragraph
is-
73, Justice Hamblin points to what he considers to be the likely uncertainty were relief to be granted.
Yes, what he does in those paragraphs is to decide on the basis of policy what's appropriate on those facts.
Sorry, I've taken enough of your time on it.
No, obviously, what is occurring, and in my submission, there is a danger of, and you have this point to a degree already, of reading these recent cases, which are all about personal property, where they are working out what is ownership in personal property law in relation to chattels. Whereas in real property law, we've had this for a very, very, very long time. There's been a very clear line. It's very established. There's a danger that just because we've got some cases now about chattels, of transposing those statements into the real property context, whereas the real starting point is the established boundary line of interest in land. On the On-Demand and Michael Gerson case at page 638, this was a finance lease agreement of video and editing equipment. And the lessor there was entitled to rent for a period of 36 months at a rate in order to recoup his costs. And the lessee was then entitled to indefinite possession for a nominal rent. Going back to the point that my Lord Briggs made a moment ago, in terms of an expectant interest, at the end of the lease, he could sell the equipment, keep it, and he was entitled to retain 95% of the proceeds on any sale, which is why he had that expectant interest. And if we go to, take that with me. Perhaps if we go firstly to paragraph 29 on page 649, which is in Lord Millett's judgment. This is a paragraph on which my learned friends rely.
649.
649, paragraph 29. So on the facts there, and going back to the original question which led to us looking at these, you can see that in the chattels context, why that is regarded as being sufficiently owning something in terms of a possessory right, that it is an analogous situation sufficient to bring into play the scope of the jurisdiction for relief from forfeiture in the personal property context.
Right.
So having been through the principal case law in relation to the extension, or rather the acknowledgement that the jurisdiction now applies beyond real property, might I just at this moment formalise what I've already said about my learned friend's arguments that relief from forfeiture simply depends upon whether the object of the termination clause is as security for performance. I won't go into what we're not clear on in their argument, but what is clear, having looked at those authorities, is that argument has been roundly rejected twice. Lord Justice Oliver in Sport International and Lord Diplock in the Scrap Trade. And it really makes no sense whatsoever if one looks at the legal landscape on it, because if it was right, then why have we been having all the discussion in the recent cases in the context outside of real property about proprietary or possessory rights? None of that would be relevant. One would only find judgments that were focused upon what the object of the clause was. Beyond that, there is, of course, a very principled point about how on earth do you discern when a termination clause has as its object merely security for performance. If this is an objective process of interpretation, how do you actually decide that the object of a clause was simply to secure performance of obligations and when it wasn't? That's a very unworkable scenario.
Why?
Well, yes, why?
Because if you simply have a termination clause, when are you going to know that its object was solely to secure performance? Or when are you also going to know that the landlord or whomsoever wanted his property back? In certain circumstances, he wanted to end the relationship. When is one actually going to know whether the payments of rent were some form of compensatory provision for expenditure or in relation to the deal as it was achieved at the very outset? It's going to be a very uncertain world on that test. But I say you don't really need to go into those arguments because it has been so roundly rejected to date. So I then come to revert to the appellant's case here, and why I say there should be no extension of the jurisdiction of relief from forfeiture beyond interest in land. And in the appellant's case, in the written document, we've set out in a good detail some of the considerations of certainty on this aspect of the matter. And I wasn't proposing to repeat those here. Essentially, we say there is a great deal of importance in certainty in commercial transactions.
I mean, this is just repeating what Lord Justice Oliver said. I mean, we've got that. And you say there's a perfectly clear contract here. They knew what they were doing. They granted a license. And once you get away from that, you're creating an area of uncertainty.
Yes, and we go into the features of that. And as I say, I wasn't proposing to repeat all of our points about the extension of the jurisdiction at all. But there are serious and significant problems in the real property world, I say, if the jurisdiction was extended. And I'll come back to that later on. But given that certainty is so critical to land transactions, we must be very careful in my submission, and I'll revert to that later on.
Well, are we still on issue 1, or are we moving on to issue 2?
I haven't dealt with it in that formulation because they overlap so much, but I think we're about a good way through the point of principle, my lord, if that assists.
I mean, I think we see there's a very tricky issue we have to decide, and we've seen strong statements by judicial authorities, highly respected, going both ways. And I get your point that really the sort of extensions have been in the context of personal property, where you have problems of deciding the right jurisdiction. As you say, in the context of land, it's all perfectly clear and has been clear for a very long time.
Yes, and just to throw out a few examples, is it going to be the case that people are having had years of understanding the significance?
No, we understand all that. I'm just trying to summarise it so we can move on.
Well, I was going to give you a couple of examples, very briefly. I promise I'll be brief, but just some practical examples. We know that a lease is meant to be a stronger interest and a more precarious licence. Are we going to be in the situation where, in fact, a licensee, someone's going to want to have a licence on the argument so that they can have a more generous approach to relief and forfeiture? They're not subject to the time limitations. Are we going to have that? Are we going to have a bizarre scenario where there's uncertainty about whether somebody has got possession sufficient for a lease or possession sufficient for relief and forfeiture under a licence? We're going to have some very unfortunate distinctions. We're going to have tremendous uncertainty about the issue of when relief doesn't apply, and this come on to this in relation to the licence in this case. But if you have uncertainty about whether relief is going to be applied, that can be a serious problem in relation to relief and forfeiture, because you can have tremendous uncertainty about where the ownership and rights in relation to a property exist while you've got the potential argument about whether the relief and forfeiture exists.
I mean, that happens on an almost daily basis in relation to leases. And there's some wonderful conceptual analysis from Sir Robert McGarry, among others, about just exactly what the situation is during a period when there's an outstanding, unresolved application for relief from forfeiture.
That's right, but this takes it a level beyond that, though, my lord. It takes it a level beyond that, because you aren't just having that established position in relation to what is known as the twilight period. Here, you've actually got a dispute about whether the jurisdiction is going to apply or not. So you've actually got to have that, which is what we've been litigating about.
But sorry, all I'm putting to you is that it's not that shocking to property lawyers that their arrangements may create that sort of limbo from time to time.
That isn't shocking, but it's a much more shocking scenario for the parties and property lawyers to know whether it's a situation whether a right is going to end or not. I absolutely accept my lord's point, but this takes it to a different level.
From the point of view of the coherence of the law, there has to be a principled reason why it's available in one case and not the other.
And what I say is the point from the beginning, which is that in property law, one has already worked out when one owns something, and that's by the rules on interests and estates in land. And that has worked very, very well for a very long time. And when we've looked at some of the other matters which are relevant to the licence, what I say is that if we change that boundary line, it will cause upset in other areas of property law.
But does that work for personality once you accept that the right of forfeiture, relief against forfeiture can be available outside real property? Don't you have to have a distinction which will apply equally to both?
In answer to your question, nothing that I say about our test upsets or is in contradiction of personal property law. It's very much part of our case that it is exactly at our boundary line that that objective of equal treatment is precisely achieved. So our case is the one that is based upon an equal matching in my submission. And it's my case that in relation to real property law, the principle has worked very well in tandem with other areas of law on easements, on leases, on relief, upon the existence of statutory legislation. Nothing that I say about why it is within its established scope and why it should stay within that causes any upset whatsoever in relation to possessory rights and the law as it's developed to date or in the future on that. I say they would be an exact simultaneous treatment in that scenario.
Okay.
Including incorporeal rights.
Including corporeal rights. There will be equanimity.
Thank you.
And just to round that off, what I draw to your attention is that whereas we have put forward extensive reasons based upon certainty and policy why the established rules would pertain, there is nothing in the respondent's case which points to any reason of policy why there should be the extension, or however one seeks to describe what they're seeking to do by saying that relief from forfeiture can apply to licences. There is no policy reason advanced by them. And that must be very fundamental in relation to drawing the boundary line, we say.
You go so far as to say that in relation to personal property, the contractual right which may attract relief from forfeiture has got to be a right to indefinite possession.
No, I don't seek to say anything about personal property law. I don't seek to define the test of personal property law. I'd probably be guilty of the same criticism which I'm advancing for respondents if I seek to do so. What I say personal property law test is based upon when you have a form of ownership. So in the real property world, I'm saying that ownership is by reference to a freehold interest or an estate or an interest in land. In personal property, they're working it out but as we've seen on those cases, and an indefinite right to possession is obviously something which so far they have regarded as acceptable.
Even where that falls short of true ownership.
Even where that falls short. Just in the same way that relief from forfeiture can apply to a 2-year lease or a 6-month lease.
But if we were, if it's right that in relation to personality, equity can step in relation to a form of possessory right which is indefinite, even if it falls short of ownership, why shouldn't equity be able to step in this, I suspect, highly unusual circumstance of a perpetual licence? I'm not sure. Actually, I have come across a perpetual licence before, but only once.
So,
in fact, we had to have a piece of litigation to see if it was perpetual or not.
I found a reference to it, I think, in McGarry and Wade. But so dealing with that question, they have decided, when they drew up the contract, to have a licence. In accordance with those principles that we looked at in IDC Clark, they agreed, and it is consistent with...
I accept all that, but you both agreed it was a perpetual licence.
Correct.
So there was indefinite...
a perpetual licence isn't an interest in land.
No.
It's not owning something.
Absolutely. But it is a form... I mean, I know you've got arguments about the extent to which it was possessory at all, and putting those on one side, just assuming for the moment against you that it has the sufficient quality of possessoriness,
yes,
as the Court of Appeal found, it is perpetual. So it is, albeit in relation to land, a right to indefinite possession falling short of ownership. So my question comes back is why isn't that good enough just because land's involved, where it is good enough if personality is involved?
Okay, so there are a number of points, I think, in answer to that, my lord, in no particular order. Firstly, when you're looking at perpetual in relation to this licence, it is not as the situation in relation to the personal property. It is perpetual, subject to a right of termination. That right of termination could have been inserted for various reasons. There is no proposition in the findings in this case from which it can be said that the only object of that right of termination was security of performance. That was never argued at first instance. There is a statement by the first instance judge that we, once he'd made it, challenged on appeal, and the Court of Appeal made no findings on it. So insofar as one says it's perpetual, that's only part of the story, and this is quite important. The licence construed as a whole was a licence that was terminable in certain circumstances, and the purpose of that clause could have been for various reasons. So it's not a situation where you have a perpetual right forever and, as in the personal property cases, a potential proprietary ownership right. But in any event, my lord, the way that the law in relation to real property probably answers your question best is that it has decided that in relation to a lease that can be for 6 months, that relief from forfeiture is applicable. It is not dependent upon any form of indefinite possession. The priority that the law has given there is the ownership element of it. The fact that a lease, for a term certain, gives you a piece of ownership, which is why, therefore, relief from forfeiture can apply even if it's 3 months, even if it's a week. It's the fact that you've given that ownership over in that form, and the law has decided you then own something. This licence, terminable in those circumstances, even though it had the word perpetual in, was not owning by reference to what the law has decided as to when you own something in real property. And it's that ownership which they decided upon which attracts that particular status.
Right, thank you.
if I was, of course, if you took the view that a possessory test was appropriate, I need to meet that case. And so I'll leave behind all the arguments in the appellant's case about why that would be wrong and deal with the fact as to, on its own terms, a possessory test. And what we say about this is there are very strong analytical and practical reasons why a possessory test is wholly unworkable. So possession may be appropriate in relation to a chattel because possession means that you have it. Land is different. Land is a fixed, immovable object where possession has to be totally different, and that's why you simply can't equate the two. That's why two totally separate set of rules. That's why possession is very relevant to owning something with a chattel, but it's not the test for ownership of land. It's only taken account of in relation to ownership of land in the lease context, where it has to be for a term certain and it has to be exclusive. So again, we can't confuse the two. But let's look at possessory in real property. Now, what was quite unusual about the approach of the Court of Appeal in this case, which I'll come to in more detail in a moment, but the test adopted was from adverse possession. Now, I make no hesitation in saying that has to be wrong. It has to be wrong for these reasons. In relation to relief from forfeiture under a granted right, the object of the exercise is to construe the right which is granted. Adverse possession is a very special, small chapter, well, it might be long in detail, but it's a very discrete, limited area of property law which has decided that in certain circumstances, long usage combined with certain circumstances on the facts and intention will actually clothe you with a title to land. That is therefore a test which is based upon a particular situation that can arise where you are examining the facts to describe whether it's appropriate to confer that paper title. So therefore it's a very different scenario from actually construing a grant to decide whether a grant conferred a possessory right. And I say therefore it confuses factual occupation with a right granted. So then, if we can't use the possessory test from adverse possession, where do we go? Well, in fact, it's quite clear that even the respondents seem to accept it's a troublesome test. They say that it should be flexible and depend upon the facts and circumstances. We say that's no way to go about developing guidance for real estate transactions, which parties need to know the clear rules on from the outset when they're actually granting the rights in the beginning and knowing what their position is. We can't have a situation where you just work it out on facts as one goes along. So we say that it really isn't an appropriate form of test in any event. And why should we start developing all of that when the law has never decided to use possessory as a specific or clear test in relation to defining rights in real property generally?
Why isn't it enough that the court would protect your right to use the property?
Why isn't it enough for the court to decide?
Courts might find that an easier test to apply than some of the others.
A test of possessory.
When you're entitled to relief from forfeiture in the absence of an ownership.
Well, I think the answer to that is that we've got very clear lines as to when you own something. Forgive me if I'm missing the point here, Lady Arden. We've got very clear lines about when you own something as a result of many, many decades of that being worked out. And if we've already done that exercise over those decades, I say, why isn't that, therefore, the established boundaries already? Why should we have a circumstance where I've been careful not to include the numerous clauses principle in this case, which you may recall is that principle about clear specific interest. But there is obviously a certain analogy with the argument that we're putting forward about keeping clear lines. And I'm not, for one moment, engaging any competition as to whether certainty is more important in real property law or in commercial transactions. I'm not saying they're just different. They have different considerations. But one of the considerations of certainty in property law is that when parties are agreeing on the status of their right, they should know what consequences follow. And what we're saying is that if you've got what the law accepts is ownership by way of an interest in land or an estate in land, then at the moment we have very clear consequences following, and relief from forfeiture isn't one of them. And if we start to then have it on the basis of a court deciding, we're looking at the wrong end of it. We should be looking at the start when the parties are entering into their transaction. And they shouldn't be entering into transaction with the potential for uncertainty and the potential for litigation to work those rights out. So that's why I think I say it's not sufficient for the court to decide when it's going to protect something. I don't know whether I've answered your question.
Well, not directly. The fact is that it will be fairly clear when the court will protect the use of property where that use is conferred by a contract, whatever name you call the contract, and where it will not do so. So it would seem to meet the test of certainty. But I think your answer is, well, we've always had property rights, and therefore it should be linked to a property right in land.
Well, of course, in this case, the parties could very easily have done it if they decided on an easement.
I mean, your point is quite simple, isn't it? That here the parties, for whatever reasons, decided back in 1962 they wanted a licence.
Exactly.
They didn't want something more.
Yeah.
And they knew what that meant. And it's this well-established meaning. And so you say, well, too bad.
Yeah.
Whereas in the context of personal property, we don't have that clear distinction. So the courts have been struggling to find a logical distinction. But I think your main position is, well, we don't need to do that here. We've got a clear distinction.
That is a correct summary.
Right. Well, let's move on then to what possessory means, if you've got anything more to say on that.
Well, what we say is that there isn't any clear meaning to possessory. I can't really help you further in relation to that.
All right. So there you are. There isn't a test.
That's our submission.
You say it's not a very good test if you don't know what it means. Right. I understand that. But assuming you have to apply that test, we then come on to the question, well, was the Court of Appeal right to say that it was satisfied here?
Perhaps it's a good moment to take a slight change of it, move on to something slightly different, which is the licence itself in this case.
Well, that starts to answer that question, doesn't it?
It does.
Can you give me an MS number for the best plan or drawing or visual description?
Well, there's no particularly good plan.
Give me your favourite.
I'll take you through the few and to find out what the object, because there isn't actually a plan that's going to...
It just helps to have it fresh in one's mind.
Yeah.
There's one attached to the Court of Appeal judgment on page 146.
It is, but that sort of shows the apparatus as opposed to the actual land. Perhaps I could ask you, if we go to the licence itself at 196, and I'll show you by reference to two plans, I think it's going to need to actually explain the configuration. And the plan that was attached to the licence is at page 210, which has got two little plans on it. Mm-hmm. And if you go to the top one of those, you'll see a big area edge red, and then you'll see a smaller cube above it.
Yeah.
Do you see that?
Yes.
So if you then look above the small red cube, And beyond that, you see the Manchester Ship Canal.
Yeah.
The area of land with which we're concerned is that little triangular configuration shown in black.
Right.
That is the area of land over which rights under the licence were granted.
So the small red cube is part of Vauxhall's land?
It is. Everything in red is part of Vauxhall's land. And the little cube was transferred to Vauxhall by the Manchester Ship Canal Company in the deed of exchange.
Sorry, in the what exchange?
In the deed of exchange.
In the deed of exchange, yes.
And I know that my learned friends will want to go to the deed of exchange, and as that's first in time, perhaps I should take you to that very briefly and the plan attached to that.
Which page is that?
So that is at page 211. Thank you.
Which is a rather more detailed.
Yes.
So if one looks at that plan at 219, the green land is what my clients, Manchester Ship Canal Company, gave to Vauxhall.
Yeah.
And the pink land is what Vauxhall transferred to the Canal Company under this deed of exchange. Pausing there, of course, it would have been open on the parties on this deed of exchange if they'd want to reserve easements for the benefit of that land to have granted them then, but they chose to do a separate licence.
And the slipway, is it under the M of Manchester?
No, I don't think it is. I could be wrong on that, but I was going to take you to the... If you go to the plan at the bottom of 210,
Yeah.
and this might help Lord Briggs on most of all, potentially,
Yes.
because if you look at the red line on the bottom of this bottom plan, you'll see land belonging to Vauxhall Motors.
That's the small red rectangle.
It is, yes. And so you'll see that the area above that red line and before where it says Manchester Ship Canal is a larger depiction of what we looked at a few minutes ago on the top plan as being that little black triangular section.
Right.
Now, so the parties enter the deed of exchange and they enter this licence. Now, I'm going to, in a moment, take you through quite a detailed reference to some of the provisions of this licence when I go through my arguments. I'm not going to go through it at the outset in the interest of not repeating myself.
Sorry, what are you trying to do? We've seen the licence, we've seen the summary and the statement of facts.
Yes.
And we've seen
Exactly.
the point about the clauses which emphasise it's a licence.
Yes.
And so on. What more are we getting?
That's precisely the point. I'm not going to take you through it as a matter of outset. I'm going through it by reference to focused argument in a moment. But by way, therefore, of the Court of Appeal's approach to this licence, let me say at the outset, one of the main criticisms that we make of that approach is that it did not focus specifically on the full grant as expressed in this licence. It didn't deal with what the actual restrictions on the rights were. It was more focused upon actual use as opposed to interpreting the rights. It overlooked all of the law on easements which we'd set out to the court, which I'll expand on in a moment. And it mixed up relief from forfeiture in the context of real property and in the context of chattels. And one of the most important findings that those criticisms are based upon is that the Court of Appeal accepted that there was no proprietary right, nor was there any possessory right in the soil, i.e. the land itself.
Yes, well, we got that, and that's in your favour.
Indeed so.
Yes.
And that's why it's say that was then messed up by looking at actual use as opposed to grant of rights, and by reference to mixing the law on chattels with the law.
Yes, well, we've seen all that. You were going to refer us to passages in the licence, which you said were helpful.
I'm going to come to that later.
No, I don't want to spend a lot of time on it. You know, like I said, we've read it all. We understand
Yes,
it. If you've
absolutely.
got points to make, let's get on and make them.
So the first point about that is that we say the character of this document was a character which was about the discharge of rights. That's what the objective of this document was. That's the character. That's the categorisation.
Discharge of what?
Discharge, drainage.
Right.
And it was a surface water and trade effluent, you may recall. That was the essential right in clause 1.1. And that being the case, that right could not be a possessory right in character. It cannot be a possessory right in character because a right of discharge is an easement. And in the law of easements, one of the requisites for something being an easement is it's not possessory. So we already have an acknowledged state of understanding in the law that rights of discharge are not possessory.
Does that characteristic of the law of easements go any further than saying that it's not an easement if it grants exclusive possession?
I think to a large extent that's absolutely fair. It might be slightly oversimplified, my lord, but in Moncrieff and Jameson, can I take you to Moncrieff and Jameson, if I may, because that might assist on that particular question. If you go to page 1147 in the second bundle of authorities.
Sorry, page?
1147.
Thank you.
This is a Scottish case, but there are various references in the case to the fact that English law and Scottish law weren't for any material purposes different on this particular point. The facts were that it was a dwelling house. It sounds as though it was in a beautiful location, but it was on the seashore. It was a very steep rise up via a stairway to a boundary fence. And a servitude right of access had been granted for pedestrian and vehicular use from the public road above, which was wide enough for vehicles to not only move along, but also to turn and park. And the case decided that there could be a right to park by way of an ancillary right to the right which had been granted if it was reasonably incidental to the enjoyment of the property in question. But the reason that I'm taking you to this case is not in relation to the decision itself, but by reference to the discussion, which I think answers the question posed by my Lord Briggs. And
Well, I seem to have some recollection of having been involved in a fairly recent case that had to look at this in relation to swimming pools.
Yes.
fact,
Anyway, let's go to what I was thinking of that, but shall we go, where's the reference you want?
could you go, please, to 1155 to begin with?
Yes.
And paragraph 24 These examples tend to show, as in the case of aqueduct or drainage, and the decision of Messenius, to which Lord Roger of Earlsbury refers, that the fact that the servient proprietor is excluded from part of his property is not necessarily inimical to the existence of a servitude. I'm not aware of any authority in Scotland which indicates the contrary. In principle, therefore, there seems to be no fundamental objection to the right which the pursuers seek to establish. Then the next reference I take you to is 1162, paragraph 47. And here I was going to ask you to go down to letter D on page 1163.
Yes. So what are we looking for now?
So this is the discussion of how, to the extent to which the point made by my Lord Briggs is about how far does the possession principle go in relation to easements. In other words, if someone has the capacity to oust a person in relation to part of the property over which the right is, does that constitute possession and therefore mean that there is no easement?
But I mean, these cases show that you don't need to have possession for there to be an easement, don't they?
These cases show that you must not have possession for there to be an easement.
But it's something pretty near exclusive possession. Because if you have a degree of possession that excludes the dominant owner from part of his land, but doesn't prevent some reasonable use of the land as a whole, then it's okay. And that's more or less what Lord Scott's saying. Broad summary.
I'll go with more or less.
Yes.
Yes. But I mean, where does that help us here? We're trying to decide what type of quotes interest is sufficient to quotes possessory to satisfy whatever test
The references that I was going to take you to are the examples in relation to these paragraphs which discuss that proposition and set the parameters, but also, for example, those references to viaduct and drainage, which I thought might be of particular interest to you in that regard in answer to the question. So at 1167, for example.
paragraph?
Paragraph 54 at letters C to E.
Yes.
Where it refers there in those sentences to a viaduct carrying water across the servient land to the dominant land will prevent the same things. And again from, in paragraph 55, what is said about Wright and McAdam, which all go to this point, that sole actual use, factual use for a limited purpose doesn't mean that there is possession, and therefore it can still be an easement.
Yeah.
Well, exclusive possession.
Well, this is where it's very careful, if I might suggest, one of the big distinctions, and some of the recent cases bring this out, is we be very careful about what we talk about sole use or sole occupation or de facto possession, as opposed to exclusive possession, which has a legal meaning about the grant of rights. So it's a very central theme to my submissions on this element of it, that what one is looking at is not actual usage, one is looking at grant of rights. And there's a Stuart and Watts quite recently talks about this distinction.
Well, if
Sole
I have
use.
a right to send my water down a viaduct over your land, that maybe gives me an easement, but it doesn't give me a possession.
Correct.
Yeah.
Correct.
It over here, right to pour water down your drain on your land doesn't give me a possession.
Correct. You have my point, Madam.
Okay.
I'm just wondering if for your notes I should give you any other references to the viaduct examples in that case.
Well, one's probably good enough. Unless someone's saying it's wrong.
So if we have a scenario where a right of discharge has never been regarded as possessory and cannot be possessory, how inconsistent is that for any approach, as the respondents contend for, to say that this is possessory? It's as simple as that. So if that grant of rights in clause 1.1, which is the substance of this licence, is that grants the right of discharge, all that has happened in relation to any equipment installed is that is an ancillary right to facilitate the grant of that substantive right of discharge. You can't have a flow of water, a discharge, unless you have a defined channel. And it shouldn't matter that they were entitled to go onto the land to construct that. It's as simple a proposition as that. And what shouldn't happen is that we shouldn't define the rights by reference to what is said to be actual usage after the grant itself. So our case, very simplistically, is this was a right of drainage. That isn't a possessory right. Even if the test is possessory, this therefore didn't satisfy that test. Now, we provided quite a lot of law in relation to easements on the proposition that I've just advanced to you in the Court of Appeal, but none of this appears in Lord Justice Lewison's judgment. He didn't refer to any of that. What Lord Justice Lewison referred to were two cases, a case called Newcastle Corporation and a case called Simmons and Midford. And my learned friends rely upon these cases on this appeal, and they also rely upon another case called Lee and Stevenson. And so if I may deal with those cases. The first in time is the case of Lee and Stevenson, which is at page 603 of the first bundle of authorities.
I'm sorry, the page again?
603.
Thank you.
And in the paper volumes, it's at tab 7 of volume 1.
Yes?
Now, this was a case in which land was sold, and if one goes to the page 604, and a little way down that page, you see the paragraph beginning on the trial before Chief Justice Lord Campbell. It's that paragraph sets out that there was a lease of an area of land, but there was a reservation out of the demise of an ability to enter upon the land and to make a sewer or water course.
Yes.
There was also a covenant by which the plaintiff could convey the freehold of the land, but that too was subject to a reservation for construction of the sewer. And what happened was the sewer was constructed and it was used, but then the defendant, i.e. the tenant, sought to make a opening into the sewer and use it for himself. And there was an argument, therefore, whether that was a trespass, because whether it trespassed upon a sole use situation. Was there an exclusive use only of that drain? Now, viewed in the context, therefore, that what we were dealing with here was a reservation by the actual landowner, it's not particularly surprising, the result, that the landowner, having accepted to himself the right from the demise, the right to construct the tunnel and to use it. So he came with full rights of ownership already in relation to it. That when he reserved that, it's not particularly surprising that the result of that case was that there was found to be a trespass and that he was entitled to have sole use. So it wasn't the situation of an ordinary grant as such. It was a reservation where he already had full ownership. Now, there must be some caution used in my submission about this case as well, because all of it predates the learning and the significance which is attached to those words of exclusive possession or exclusive use. So words that are used in that context, and potentially inconsistently at times, as I'll show you in a moment, are not to be taken as having the legal significance in my submission that such words would now do. So, for example, the words that no doubt will be relied upon in this case, at page 605, where the Chief Justice Lord Campbell says, I'm of opinion that judgment, do you see that halfway down? Page 605. It's exactly halfway on the page.
Mm-hmm. He talks about an easement consisting of the exclusive right to use the sewer.
You have my point.
When it had been suggested that the issue was it an exclusive right or was it an easement?
Exactly. And it goes on like that, this paragraph does. It has so many inconsistencies on the rules as we now understand them, that when you see the context and the fact that the result of the decision was obviously understandable and correct, that the language used before those words and those rules are developed cannot be relied upon in my submission now, where they are so internally inconsistent on the principles. So as just been referred to, an easement consisting of the exclusive right to use the sewer is a contradiction in terms. And then the very last line of that same paragraph, where there's a reference to the plaintiff having the right to the exclusive possession of it for a particular purpose of his own, which again couldn't be an easement. And then... well,
he's adopting the test of whether or not the person would be liable to an action, i.e. whether the court would protect the use of the right.
Yes. Yes, and that is very similar to the submissions we made in our appellant's case about Manchester Airport and Dutton. You can see that the remedy there is to protect the right, but we can't draw significance from the wording about any established point of principle that is relevant to this case.
I mean, this case doesn't set out to be a treatise on the nature of easements. It's pure question of construction of the relevant grant.
Absolutely. So when one goes to Simmons and Midford, which is the case that Lord Justice Lewison referred to, and this one is at page 767, and it's divider 16 on the paper copies.
Yes.
We'll see in a moment that it's Lee and Stevenson that's relied upon. The facts of the case, if I could ask you just to look very briefly at C to D on page 767.
Yes, so what do we get from this? I mean, it gives you
So-
the exclusive right to use of the particular...
Exactly. So
Right.
that is the extent to which it is relied upon
Yeah.
by the respondents in this case, that therefore there's some exclusive right flowing from Simmons and Midford that should be applied in this context and it should be treated
Yes,
as
they
possessory.
say that's sufficiently possessory, whatever that means, to satisfy whatever test we think appropriate.
What we say is that this case is nothing to the point on it. The case does not even have anywhere in it the word possessory or possession. So it's simply not dealing with the concept at all. And it's confusing actual usage with the issue, as I mentioned earlier ago, about right to possession.
Okay.
And just to follow that through on the Lee and Stevenson point, it's at page 775, letter B, because what Mr. Justice Buckley does is simply apply Lee and Stevenson. So having referred to it between B and C and quoted from it at C to F, he says at letter F, just so in the present case.
So what do you say you should have done?
What I say is that this case is nothing to the point on this appeal. It says nothing about possessory rights which can be relevant to this right of discharge.
Thank you.
So it doesn't use the word possessory, it simply applies Lee and Stevenson's, which says nothing. And what's more, if we needed for it to be, it's very distinguishable on the facts, because if you look at letter G, it specifically says there, the plaintiff or her predecessor could not have been required to construct a drain of greater capacity than was required for that purpose. Well, after lunch, I'll show to you the provisions as to why that is very, very different from what we have here. But you have my general point that Simmons and Midford is really irrelevant to this case. Just for a note of caution, which is referred to in Lord Justice Lewison's judgment, is that most of this case was actually overruled. It's only where he goes on to consider that on this particular point that if the pipe had formed part of the freehold of the strip of land, there was no power. So most of it's been overruled, but the bits I've taken you to aren't. So the other case, which is referred to by Lord Justice Lewison and relied upon by the respondents, is the case of Newcastle Corporation and Wollaston in 1947, which is at page 654 and divider 11 of bundle 1, the authorities. I don't need to take you to the facts, which are quite complex and involve the question of a statutory provision under which there was no right of support for gas pipes and there was no compensation if mining works were within 40 yards. That's what most of the decision is about. But what this was relied upon for in the Court of Appeal judgment was that the Court of Appeal said that there was an exclusive occupation within of the space occupied by a pipe and of the airspace within the pipe. So, putting it very simplistically, this case was said to support the proposition that was possessory because in that instance the Court of Appeal had taken the view there was exclusive occupation of the pipe and of the airspace within it. So what we say about this case is it's absolutely not all square, and by a long way, with this case. First of all, the most important feature of it is that this was about statutory rights. And the position in relation to statutory rights through land is the subject of a sui generis situation. There's ample case law which says that the rights which are conferred by statute in relation to these forms of statutory undertakers. Because Parliament can decide to grant whatever form of a right it wants to, it is not restricted by reference to the ordinary principles of rights, that they are sui generis. And one feature of that, again, renders it totally different from this instance, because, of course, there, the pipes do belong to the undertaker. There are numerous references throughout this Court of Appeal decision to it being their pipes. So the pipes obviously weren't treated in the same way as the spillway equipment in our cases, where it's accepted that it's become part of the land in the ownership of my client. So once you start to see those features and the accepted law that this sort of statutory right is sui generis, in our submission, this case cannot be applied as authority to a purely contractual situation in preference to all the law on easements, which is concerned with the private rights of drainage. What is more is that pursuant to those statutory rights, none of the other rights which are in the licence, which conferred on my clients the rights to require it to be moved, the rights to use it, which I'll come on to, the rights we had over design, location, etc., none of those were applicable. So we say Newcastle Corporation and Wolstonton is simply comparing apples with pears. Is that a convenient moment?
Right, how are we doing in terms of time?
We're doing well.
Are we? So you're going to be well within...
I confidently predict I will be well before 3 o'clock, which I think is the time.
Right, we'll meet again then in anticipation at